Hi, everybody. Welcome to Debt Free Divorcee, formerly known as the Peace and Power Podcast. I'm Kiosha, and today we are talking all things child custody and child support with our guest, Candace Little. Candace is a family law attorney, certified divorce coach, certified divorce transition and recovery coach, and an advocate for healthy relationships. Candace, thank you so much for joining me today.
Of course. Thank you for having me.
Yes, I'm so excited to have this conversation because child custody and child support is always huge, going through a divorce and with so many families having children. It's just one of those things that people have to go through. They need to learn and understand how to navigate it. And so I think it's an important topic to cover. And so something that really, I think about these days with child custody and child support is, there was a time where I feel like the courts really favored the mother. And it seemed like that was, if you were the mom, you were typically going to get what you wanted. Do you see the same trend now, or is the atmosphere shifting?
The atmosphere is shifting. I have seen a lot of dads, end up with primary physical custody. And I will still say overwhelmingly moms do receive primary physical custody. But what's kind of hurting some of the moms is we're withholding children sometimes and not facilitating the relationship with the other parent and just honestly not co-parenting. And that can be a reason for you to lose custody.
Wow. Okay, that's really good to know. How is the visitation typically arranged or figured out? Like, are families or are divorcees typically coming and saying, "This is what I want"? How is that? Is it just a standard kind of breakdown? How does that process work?
So there is a standard breakdown. The standard breakdown is usually every other weekend for the, I would say dad, but for the non-custodial parent. The weekends typically vary. Like I've seen Friday to Sunday, Friday at 6, Sunday at 6. I've seen Friday to Monday. Some judges are increasingly doing Thursday to Monday and then giving like an overnight on the off week when they don't, the non-custodial parent doesn't have the weekend. So that's pretty much during the academic year. During the summer, I've seen a lot of parents do week on, week off because we don't have, the confines with school. I've seen some judges kind of favor month on, month off, just because we've had issues with, oh, well, you didn't take them to summer camp during your week, and then I had plans to go to Disney World, but you withheld the child. So dad usually gets June because of Father's Day. Mom would get July, and then we just kind of split, the remainder from May to August. And then we split the holidays. Basically, we do an even and odd year basis for most of the major holidays. Some of the minor holidays, we typically just go with the normal schedule because, a lot of people don't have those Monday holidays off from work. So it's just easier to just do whatever the schedule is as opposed to it being dad's weekend, but mom has MLK Day. So now we're doing this like random one off switch. And it depends on one, how far do y'all live apart? When you have out of state parents, the preference for them is to get the majority of the holidays because they're not here during the academic year. And then also if the parents really can't co-parent and we're looking at exchanging at a police station, things like that. We don't want to do that on Christmas Day. So
Right. So you said something about when parents live out of state. So let's say a family has their decision, they have the custody agreement, but then if a parent does decide, I have a job offer in another state and I want to move, or maybe I don't have a job offer, maybe I have family in another state and I just want to be closer to them. Like, what are the things that someone needs to do in order to say move to another state if they're the custodial parent? Can they just be like, all right, we're leaving? How does that work?
so yes and no. A court cannot prevent you from moving, right? But with most Georgia parenting plans, you have to notify the co parent within 30 days of a change of address. Sometimes it's 60 days if you're moving somewhere like out of state. So as soon as you give that notice, that secondary custodian then has the right to go and modify custody. It's an automatic material change of circumstances. I can go ahead and modify custody, and courts will generally give an expedited hearing for that reason because you're about to move. Um, I don't know what it is about Georgia, but these Georgia judges do not like you moving out of state. I have seen it go both ways. I have seen it, really negatively impact the moving parent, where you can lose custody. Um, I've seen in Georgia, when you turn 14, you can basically elect which parent you want to live with. I had a case where it was a 14-year-old, mom was moving to Texas. He didn't want to go to Texas. So he then elected to stay with dad and testified against his mother on the stand. It was very sad. But if he's in high school, my friends are here, all the things. So a court did consider that, and while mom was a terrific mom, no issues, dad was actually pretty lackluster. But that change came, and there you go. But a court, it's not so dire. I don't want it to, sound like that. But a court is going to examine the reasons why you're moving. Do you have a place to stay down there? Do you have a job waiting for you down there? Are you following another man? Are you married to this man? If you are following this man, what kind of things do we have in place to preserve that relationship with the co-parent? The distance. Like if you're moving to Ghana, that's a pretty big distance as opposed to moving to Florida from Georgia. So they'll look at all those things. It's not just, oh, you want to move? No, basically the child stay here, you can move. But it is one of those things where if you're going to move, you better have a really good reason for doing so. Because courts do frown upon it. And their thing is they want the most stability for the child. And that generally is in the same state, same house, same friends, same school system, same all the things, same doctors. They want to preserve that relationship here. And generally they do.
What about changes to the custody agreement just in general? I mean, say nobody's moving, but one parent is just not really happy with the way the custody is going and wants to make a change. Maybe dad wants more time, or maybe mom feels like dad isn't utilizing his time well. What rights do parents have to modify an agreement after it's already set?
So both parents can modify every 2 years. If something happens prior to the 2 years, it has to be a material change of circumstances. That's the threshold. Material change in circumstances has been, evaluated and looked at and analyzed by the Supreme Court so many times. Like what counts as a material change in circumstances is very broad. Um, you know, Obviously moving is a material change in circumstances. Getting married can be a material change in circumstance. When parent goes to jail, a change in work schedule, and say you were getting that off week on Thursdays, but now you work on Thursdays and you can't get Thursdays and you want to go to Tuesdays, but the mom won't let you go to Tuesdays. So that then becomes a material change in circumstances. There's no laundry list of things like if it has to be this, the courts are always open to interpreting that statute even more. I mean, it literally is thousands of cases, on that. But yeah, so every 2 years, unless there is a material change in circumstances, and then you can file literally the next day after you receive your order.
And what about parents just kind of doing things on their own? So, like, if two co-parents have an okay relationship or okay enough that they're communicating with each other and they can kind of do things, is there an impact to what is done legally by them kind of operating on their own outside of what was, necessarily agreed to in their paperwork?
So no, actually it's encouraged. Most parenting plans include language that the parties can vary the parenting time, with the example, oh, my schedule changed. Is it all right if I do Tuesdays instead of Thursdays? That's fine. The only thing you can't modify without a court order is actual custody, like who's going to have, legal physical custody. Those things cannot be modified. But the parenting time can be modified all the time. I recommend against it, honestly, because
Okay.
even if you have text messages and things like that, to the extent that someone is not going to go by the agreement, it's always going to default to what was in the court order. And a lot of times people, I don't know, those agreements, they just kind of go down the drain and we default back to the court order, but people are still relying on the agreement, which is adverse to the order or different from the order. And then we have all kinds of contempt actions filed. People are saying, oh, well, you didn't give me my parenting time. It's like, oh, well, no, we agreed to switch. And so it can get a little messy. I would say if you are going to do it with the same formality. Have it in writing. And when I say writing, I don't mean emails. I don't mean our family wizard messages. I don't mean text messages. I mean an actual document that is signed, that you both sign, and sign it in front of a notary so that we can have a witness to say that nobody was under, duress, nobody was forced. You knew exactly what you were doing. You had to get in your car and physically go to this person to sign it, because it's, I don't know. I feel like sometimes adults default back to children, and it's like, I'm telling on you, and we have all these tattletales when all we had to do was, stick to this order and don't change from it.
So let's kind of get a little bit into the support side of things. For some people, there's this idea of, well, you make more money than me, so I shouldn't pay as much as you. But then my understanding is that it's based on the needs of the child and like how much it actually costs to take care of them versus how much somebody makes. So, like, how is support, child support, determined?
So it's determined by a worksheet. There is an online website. It's like Georgia Online Calculator, I believe. If you Google it, it'll pop up. But basically, your gross monthly incomes go into this worksheet, and it has its own little algorithm that it cranks out this number. It's basically a presumptive amount, and it cranks that number out, free and clear from anybody else. I can't go in and manipulate it, but that is technically what the number will be. And it's determined by both parents' gross monthly incomes. And when I say gross, I mean before taxes. So it doesn't matter what you bring home, it's your gross. Insurance premiums. If one parent is maintaining insurance for the child's portion of the premium actually goes into childcare, work related childcare expenses, daycare. That goes into the worksheet as well, and that's calculated on a yearly basis. Those are the most standard. Insurance and childcare, those are the most standard. But then we have a bunch of other deviations that can also go into the worksheet, like extraordinary educational expenses, tutoring, private school tuition, those things can go in there. We have non-specific deviations, basically just a random, I just want to deviate down to this number. Some of the other specific deviations: dental insurance, vision insurance, life insurance for the child, the mortgage if you're still paying it, and a bunch of things. If you have other children, that will be something called a qualified child. Basically, if you have a child from another relationship and you're not receiving child support for that child gets included in the worksheet as a means to reduce your income. It basically reduces your gross monthly income because you have to support another child that you're not receiving support for. And then also, other child support orders, previously existing child support orders, those go in the worksheet as well. So if you're on your second marriage, but you're already paying child support for two kids, that number gets included in the worksheet prior to you getting divorced for your second marriage. So that also is a way to reduce your income. So we put all these numbers in the worksheet, and it cranks out this number. And I know I sound so professional by saying crank it out, but literally that's what it does. We rely on whatever this worksheet does, at least for the presumptive amount. But then we can always say, you know what, Judge, I want a non-specific deviation just because I'm paying for X, Y, and Z, or, I'm doing X, Y, and Z, or we've already agreed that I will maintain a 529 account, for our child, and those distribution or contributions on a monthly basis are going into that account. So you can be creative with it. You're not stuck to it, but whatever the presumptive amount is, that's going to serve as the guideline that we're going to go by. And then it's up to the judge whether or not he's going to take, however creative your argument is, to deviate down. And then also, we can also deviate up. If the parents have a combined income of 40,000, it used to be 30,000. Child support just got a huge cost of living adjustment in July of last year. So now it actually costs more. for the non-custodial parent. So that child support number increased. So if you have not modified child support prior to July of last year, it's about time you do. And so if the parents have a combined income of $40,000, it automatically will set the child support number and we can go up from there. Because basically, like you were saying, it is about the child. If the two of you all were living together, what kind of lifestyle and quality of life would that child have? So,
This is really educational for me because I'm really seeing how, like, fair the courts are trying to make it. Like, I hear you saying if you are the custodial parent and you have other children, there's consideration for that. If you are the non-custodial parent, the one who's paying child support, and you have other children, there's consideration for that. So, it's not this blanket just kind of thing. And, I know a lot of people, traditionally men who are the non-custodial parent, will have an issue with paying child support because they feel like they're just giving the money to the mom. But the way the courts have designed it is really to make sure that the child has coverage in those key areas. I talk to a lot of divorced, mostly women, and mostly, going to be the custodial parent, and they are nervous that their ex may be hiding money or may be, somehow able to say that they're making one amount when really they're making more. Is there anything that is out there to help, prove a case if somebody may be trying to hide money, or is it really just kind of your word against theirs?
no. So, yes, it definitely is something out there. Anytime you're going through litigation for support, I would always encourage you and undergo what's called discovery. Basically, that is you sending out requests for production of documents. And in this request for production of documents, you're asking for everything: pay stubs, tax returns, bank account statements from all of your accounts. Now I see Bitcoin requests, I see Cash App requests, PayPal requests. You're asking for all kinds of documents, text messages, Facebook, social media. So basically, to the extent I don't see your income in your pay stubs, your tax returns, your documents, business bank account statements, if I don't see it, I can still look at your quality of life and say, oh, well, Judge, he live in West Paces Ferry. Ain't no way he making minimum wage. Who's paying this mortgage? And so judges can do one thing that is called imputation of income. So basically, we can say, Judge, here is the documents that I have. They didn't produce X, Y, and Z, even though I asked for it. Look at his quality of life, look at his standard of living, and I need you to impute income to him based on these factors. And some judges can do it, they do it all the time. Even if you testify about, oh, well, I only make that, last year. I'm not going to get that this year. Judges can also, because I hear a lot of people say, oh, well, I'm commission based. I don't get it every year. Or this was a bonus. I don't get it every year. Judges are allowed to still impute that, but they also can take an average of the years. So maybe you didn't get 20,000 in your bonus this year, but you got 10 last year, you got 15 the year before that, you got 25 the year before that. I'm going to take an average of those because you're going to get something this year, and I'm going to include it as your income. I see a lot of women do this, and this is kind of what pisses me off with us sometimes is, we'll go to college, we'll get our MRS degree, right? We'll have our first child, and then, we'll say, oh, I don't want to work no more. And when it's time to get divorced, you want to say that you're incapable of making a significant amount of income, but you got two PhDs, you was working before he met you, you were doing all these things prior to having children. So there are vocational experts. I've hired several of them, and they can basically testify to a judge and say, this is what I think she is capable of earning. They look at your resume, they look at your previous experience, they have whatever qualifications as career assessments, and they can testify for a judge to say, you know what, Your Honor, it is in my experience, someone with her qualifications, someone with her work experience, she should actually be imputed at $65,000 as opposed to $30,000 that she's actually telling you that she can make.
Wow. Okay, girl. Wow. But you know what? Fair is fair.
Fair is fair.
Fair
Fair,
is fair.
fair.
So for everybody out there, y'all need to watch what you out here posting on social media. You can't be over here saying, "Oh, I can't pay no child support," but then you out here on social media buying the new J's and out here flexing with your new, Gucci, whatever. Like,
Exactly. And then with just with custody, same with child support, it can be modified every 2 years. Unless there is a material change in circumstance. If you hit the lotto, wait a minute, let me take you back. Or if you lose your job, you can then say, you know what, I've had a decrease in income. So like you said, it goes both ways.
for some people, like for me, I went through the entire divorce process. I had a lawyer, but we agreed on everything outside of that. So everything was not there was no we weren't contested, right? Like we agreed on everything. We got it all buttoned up and the process was pretty easy and simple for us. What kind of resources are out there for people who either A can't get a lawyer? Like can you basically do a divorce and child custody for yourself?
Absolutely. I always say Fulton. I want to say Gwinnett does as well, but Fulton has a family law workshop. Gwinnett has a divorcing parents seminar. All the courts have the documents online. The petition, the parenting plan, the child support calculator, the settlement agreement, all those are online. And if you can't figure out what's in your county, if you take something from Fulton County's website or Gwinnett County website, it's the same thing, just change the county name. Like it literally is the same. It's all Georgia law, it's all from the statute. Every judge has a staff attorney who assists them with moving their docket. I've seen numerous amount of times where people who are pro se, that means you're not represented by a lawyer, so you're pro se, they go to court, they have an agreement, but their paperwork is messed up. And so the judge, brings you into court and says, well, you know what, I want to help y'all, but y'all are missing XYZ document. And without giving legal advice, sometimes they will either tell you, and it depends on the county too. Some counties, they'll say, go meet with my staff attorney. Staff attorney will basically fix it and y'all can go ahead and get divorced. Some judges will tell you, this document is messed up, feel free to hire a lawyer, or you have to come back at a later date. I've had people hire me for that limited purpose, to basically fix paperwork, do those things. So even if you didn't want to retain a lawyer for full services, you could still have someone help you get your paperwork together. And then also, I do consulting as well. So if you just wanted to, pay a consultation fee just for me to tell you what you need to do, we can do that as well. So yeah, do you absolutely have to hire a lawyer? No. I think if you're going to reach an agreement, you really don't need a lawyer. I would just say make sure that with that agreement, you are knowledgeable of everything that could possibly be in that agreement. You don't want to say, "Oh well, I'll agree to 500 in child support," and he got 7 other jobs and millions in the bank. You don't want to do that. But yeah.
Yeah. Okay. So one more thing, and I think this is very important for people to understand. You got separated, as in I moved out or I told him to move out, and then you have legally separated, and then you have divorce. What do people need to do if they're kind of in that limbo phase? So we're not divorced yet and not quite ready to say that we're going to get a divorce, but we're separated. If we want to separate things financially, like what do people need to know about that separation period and how to make sure that they're not kind of tangling themselves in a web that they can't get out of?
Well, so moving out, but no one has filed anything. I refer to that as a bona fide state of separation. There's typically not much going on here because, whatever y'all are doing is what y'all are kind of impliedly consenting to. If you move out, though, technically, you're kind of giving the other person the house. If the kids are still there, you're kind of by default making the other person the primary physical custodian. If you're not paying any child support or if you're paying the mortgage, you're kind of, you know, by default making yourself be the one who's going to have to pay, some kind of child support. In that situation, if you can live like this, I mean, that's what you're going to do. but it's kind of hard to have some oversight if there is no order in place. Now, if I recall correctly, if I remember correctly, there are some county child support offices that will go ahead and establish an amount of child support, even if y'all are still married, but y'all are living separately. Um, Now, so Georgia doesn't have legal separation. Is that, I mean, it is, but it's called separate maintenance. Now, you can file what's called a petition for separate maintenance, and it goes through the same process as it would with a divorce. You can, handle custody, you can handle support, you can handle alimony. The only thing that you cannot handle in a petition for separate maintenance, technically, is a division of property because at this point, you guys are still married. You're just separated. Um, so you can do that, but to the extent one person wants to actually get a divorce, if they counterclaim in this action for a divorce, then it's going to automatically turn into a divorce because the judge is not going to make this person stay married to you. And then actual divorce, you go through the same process as you would normally. The biggest thing I would say do if you have a divorce where we got multiple assets, we have children, we have things that I can't wait 6 to 12 months for a final order. I would say schedule a temporary hearing as soon as possible. If you can reach an agreement on a temporary basis, great, but if not, I would say schedule a temporary hearing, get a judge, get in front of a judge to go ahead and give a temporary order for custody. So the kids are going to stay with me. This is the time that you're going to have. Get a temporary order giving you exclusive possession of the marital residence. Go ahead and change the locks. Let him get his stuff or let her get her stuff, so that you can, basically start to move on. Get a temporary order for support, or sometimes if you're paying the mortgage and paying all these other things, judges won't impose a support requirement because you're paying all these other things. Um, if you can agree, because once you file for divorce, there's a standing order that comes into place where you can't sell anything, you can't move anything, you can't start, disconnecting the utilities unless y'all agree. So if you agree that neither one of y'all want the house, go ahead and sell it. Split the proceeds or let the proceeds be paid into the registry or held in one attorney's escrow account for division later. But that way you're both out from under that mortgage if you already know you want to move on. You can also agree to, divide certain accounts if you want to. Y'all got a joint account, but y'all just going to do things differently. Split it, close it, save it. So, you have a lot of options in a divorce. If you can agree, great. If not, go ahead and get some kind of temporary hearing scheduled.
Yeah. Okay. This has been so good. So much good information. I really think people are going to get a lot out of it. But I want to give you an opportunity. Do you have anything that you run into a lot, or anything that you think that people just really need to know about going through this process of divorce?
For women with children, um, going through this process, get prepared for a loss of control. I see a lot of my moms, you've already been doing everything, the kids are, pretty much within your gambit, your rule, and what you say goes while you're married. But then they go to dad's house whenever things start to separate, and you want to have a say so of what goes on over there. What time are they eating? Are you doing their homework? What time is bedtime? Who's coming over your house? Who are around my children? I would say start to prepare for that, because that is kind of where I see women start to go wrong, even though they're well intent, or they have good intentions. But then it starts to become where you're a helicopter, and then courts start to frown on that, and then dad gets sort of the benefit of the doubt. Even I'm not saying that dad would get custody because of that, but just go ahead and start preparing yourself for that. And then honestly, don't expect your spouse to do during divorce what he or she did not do during your marriage. So I would just say lower your expectations, let them go. Don't have anyone going through this process. You are about to meet the person that you thought you were married to.
Ooh, that's good. Oh my goodness, Candace, that is so good. But I didn't expect anything less because amazing.
Oh,
Uh,
thank you.
please let us know, how can people reach out to you? How can they get in touch with you if they wanna hire you, if they just have questions?
Oh, yes. So if you are in need of a family law attorney, please call my office. My office number is 678-949-9756. And if you want to simply connect, you can follow me on Instagram at Attorney Little.
Yay, thank you so much, Candace. This has been amazing. I truly appreciate you, and I thank you so much for your time today.
Always, Kiosha. Thank you.